Hi everyone, this is Professor Swati Tyagi, Assistant Professor at IMS University Courses Campus. The topic which I've taken for today is gratuity. You might have heard this term, maybe in your homes, maybe from your parents or grandparents. So it's an interesting topic to discuss about. Actually, a very beautiful social security legislation, which is covered under the Payments of Gratuity Act 1972. So let us quickly talk about the concept gratuity. This word is derived from Latin word gratuitas, which simply means gift, treated as a gift from the employer to his employees. So this is something which the employer gives to his employee for his long-term services, for his loyal services to the organization. So it is paid by the employer to his employees for his past services when the employment comes to an end due to retirement or superannuation of the worker. So this is something which the employer gives to the employee. So let us quickly look into the history of the concept. In the 1950s, gratuity was a scheme which was introduced by the employer, which they give to the employee for their generous because of their generous nature and their long-term association of the employee with the organization. Then in 1970s, the government of Kerala made it as a statutory right of the employee. And in the year 1971, West Bengal government also introduced a law, which is the Payment of Gratuity Act 1971. Basis on this act, in the year 1972, central government enacted this act for the entire country and made it legal. And now it has become a right of the employee to claim for the gratuity amount. This act came into force on 16 September 1972. It is a law, as I just mentioned, which mandates employer to pay gratuity to their employees upon their retirement, resignation, or in case of death or disability after a specified period of service. Gratuity is a lump sum payment calculated based on the employee's last drawn salary and years of service. It is no longer considered a bounty, and the employees are entitled to claim it as a matter of right. It extends to the whole of India. The objective behind the act was to provide a social security method to the employees after retirement. It also acts as a social security legislation to the working population, to the wage earner population basically. It also envisioned as a reward for those workers who have served for a long period of time as faithful employees. It also imposes a statutory liability upon employers to provide the amount of gratuity to their employees. Let us look into the applicability. It is very important while we are studying a law to look into the applicability of it. How and in which areas the law actually be applicable. So this act is applicable to all the factories, mines, oil fields, plantation, port and railway companies. To every shop and establishment in which 10 or more employees or workers are employed on any day of the preceding 12 months. So a shop or establishment to which this act applies will be there even if the number of employees goes down from 10. So once applicable, always applicable. So since we are studying an act, it is important to look into certain definitions as well. So the first definition which comes in the act is the appropriate government. Who will be the appropriate government to take decisions? So in case of establishments which are belonging to the central government or comes under the central government or maybe having branches in more than one state, they'll be coming under the central government. So the appropriate government in that for those establishments will be central government. For example, the LIC of India, BHEL, Bharat Petroleum, HP, etc. And the rest of the establishments, the state government will be the appropriate government or the decision-making body. The employer, for the purpose of the act, will be, in case of central government employees, who will be the employer for establishments which comes under the central government. That person would be the head of the ministry or department or the concerned department. In case of local authority, the chief executive officer of the local authority, and in other cases the manager or managing director of will be the employer. Employee, if we talk about employee, means somebody, any person other than an apprentice who is employed for wages, whether the terms of such employment are expressed or implied, employed in any kind of work, manual or otherwise, employed in and in connection with the work of a factory, mine, oil field, etc. So, this person will be called an employee who should be under an employment contract, maybe working on a manual work or otherwise. That person will be considered as an employee. It becomes very, very important that you understand the definitions of these terms, because then only you can check the applicability, right? So the factory will be factory will have the meaning as assigned it in the clause M of section 2 of the Factories Act 1948. If we talk about family, family will consist of the employee, his spouse, parents of the employee and the spouse, and their children. The word retirement will mean termination of services of an employee, otherwise then on superannuation. Superannuation is a new term. Let me quickly tell you what it is. It means the attainment of the employee of such age as is fixed in the contract or condition of service, at the age of the attainment of which the employee shall vacate the employment. Controlling authority. The appropriate government may by notification appoint any officer to be the controlling authority. This person will be responsible for administration of this act, and different authorities may be appointed for different areas. Alright. So the definition for wages will be all emoluments which are earned by an employee while on duty or on leave in accordance with the terms and conditions of his employment, which are payable or are paid or are payable in cash, and include DA, but does not include any bonus, commission, house rent allowance, overtime wages, and any other allowances. So we need to be cautious while we are looking into the wages. It would include basic salary and DA, but exclude bonus, HRA, overtime, and any other allowances. All right. Now let's look into the eligibility. Who all will be eligible for the payment of gratuity? So the first and primary condition to be eligible for the amount of gratuity will be the continuous service for at least 5 years. An employee should be in the continuous service of the employer for at least 5 years, and he would be eligible for the amount on his superannuation, on his retirement, or on his resignation. However, the employee will also be eligible for the amount in case of disablement and on his death. If we talk about continuous service will include interruption caused by sickness, accident, leave, layoff, etc., but will not include absence from work without leave or cessation of work due to fault of the employee. So the employee has to be in continuous service. The service may be interrupted because of sickness, accident, or maybe layoff, but it should not be stopped, or the cessation should not be because of the fault of the worker. So if a worker has worked for 1 year, he should be there in the employment for at least 240 days for a normal case, in the preceding 12 months, and 190 days in case the worker is employed in an establishment which works underground, for example mines. Let's look into the calculation of it. So here it is the formula, which is 15 into last drawn salary into number of completed years divided by 26. This is the formula which we use for calculating the gratuity amount. However, if the employee is in a seasonal employment, the number of days will be 7 instead of 15. The maximum limit for gratuity is rupees 20 lakh as per the new rules. The payment of gratuity is the employer's duty, or it is his liability. So, irrespective of the fact whether the application has been made, the employer shall determine the amount of gratuity and give notice in writing to the person to whom gratuity is payable. He should pay that amount in 30 days from the date of gratuity become due. If he is not able to pay the amount in the 30 days, given 30 days, then he shall be paying the amount with simple interest. So if the amount is not paid within 30 days, the employer shall pay in simple interest from the date of gratuity becoming payable to the date on which it is paid, and the rate will be decided by the central government. The amount of gratuity can be forfeited as well. So here are the conditions on the basis of which the amount can be partially or fully forfeited. So the first condition will be any negligence shown by the employee, willful omission caused by the employee, any damage to the property caused by the employee. In such cases, the amount of gratuity can be forfeited to some extent, or the extent of damage or loss so caused. The other condition is if the employee is involved in some righteous or disorderly act, or may have created some violence on the campus, then in that case the entire amount could be forfeited. To pay the liability of gratuity, the employer should take compulsory insurance. It is mentioned in section 4 of the act. It is the liability of the employee to pay off the gratuity amount, so he should take an insurance for the same. He could take that from LIC of India or any other prescribed insurer. However, in case of employers having more than 500 employees, they could establish their own gratuity fund and pay off the amount when it becomes due. Appeal to an order. So any person aggrieved by the order made by the controlling authority may, within 60 days from the receipt of the order, appeal to the appropriate government or authority in this behalf. After being satisfied with sufficient cause, he may extend this period by a further period of 60 days. In case the employee is not satisfied with the order of the controlling authority, he may appeal to the further appropriate authority within the next 60 days. And lastly, let's just quickly look into the penalties. If the person is not complying with the law, then he or she needs to pay the penalty. The employer needs to pay the penalty. So the first case is the penalty for avoiding any payment to be made. In this case, imprisonment of 6 months or a fine of 10,000 rupees, or both could be caused to the employer. In case the employer contravenes or defaults in compliance of any provision of that, he or she shall be liable for imprisonment of 3 months to 1 year. Fine could be from 10,000 to 20,000, or both of it. And lastly, non-payment of gratuity. In case the employer does not pay the gratuity amount, then the employer shall be punishable with imprisonment of 6 months to 2 years. So this is the Payment of Gratuity Act 1972. And with the pictorial description of the entire act, it becomes easy for you to understand. This is a very short act, and I've explained in the shortest possible manner. And that's all from my side. Thank you.